or deliberations to this matter. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have the foreperson sign his or her name to the particular form that conforms to your verdict. You are instructed that a person commits the offense of driving while intoxicated if the person is intoxicated while operating a motor vehicle in a public place. In this regard, public place means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Motor vehicle means a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device exclusively on stationary rails or tracks. Intoxicated means not having the normal use of one's mental or physical faculties by reason of the introduction of alcohol into the body. You have heard evidence obtained as a result of a traffic stop and detention of Officer Alejandro Gonzalez by Officer Escobar. Specifically, you have heard testimony of Officer Escobar and other state's witnesses suggest that Alejandro Gonzalez might have been operating a motor vehicle while intoxicated. You may consider this evidence only if you resolve a preliminary question in favor of the state. No evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America shall be used against the accused on any trial of any criminal case. The state must therefore prove beyond a reasonable doubt that the evidence was not obtained in violation of the law. A police officer may, under the law, stop and detain a motorist without a warrant when the officer has reasonable suspicion that the motorist has committed a criminal offense, including a traffic offense. You are instructed that an operator on a roadway divided into two or more clearly marked lanes for traffic, A, shall drive as nearly as practical entirely within a single lane and may not move from the lane unless the movement can be made safely. An operator that violates this provision commits a traffic offense. In this regard, operator means, as used in reference to a vehicle, a person who drives or has physical control of a vehicle. Vehicle means a device that can be used to transport or draw persons or property on a highway. Police officer means an officer authorized to direct traffic or arrest persons who violate traffic regulations. Before you may consider the evidence obtained as a result of Officer Escobar's stop and detention of Mr. Gonzalez, you must all agree that the state has proven beyond a reasonable doubt that Officer Escobar reasonably believed that Alejandro Gonzalez was failing to maintain a single lane before Officer Escobar stopped him. If you find that beyond a reasonable doubt, then you may consider all of the evidence obtained as a result of Officer Escobar's stop and detention of the defendant. If you do not find that fact beyond a reasonable doubt, then you will disregard all the evidence obtained as a result of Officer Escobar's stop and detention of the defendant, and you will find Alejandro Gonzalez not guilty. Now, therefore, if you believe from the evidence beyond a reasonable doubt that the defendant Alejandro Gonzalez on or about July 25th, 2025 in Harris County, Texas did then and there unlawfully operate a motor vehicle in a public place while intoxicated, then you will find the defendant guilty of driving while intoxicated. If you do not so believe or have a reasonable doubt thereof, you will find the defendant not guilty. I now will sign the jury instruction form, and closing arguments will now commence. State?
Yes, Judge. Should the technology working?
Did you want to split? Or you weren't doing everything?
We're going to split it open and then save time for rebuttal. So,
And how much time did you want now? Or did you want to do half and half?
no, just 2-3 minutes right now.
Okay. Just, I guess, let me know.
I don't know why it's. Yeah, when we started this trial, we told you to come down to one simple truth. It's something that we all teach our kids. It's a universal truth that we all know. Choices. And choices have consequences. Right? It's something that we know so much that we're raised in it. We teach our kids it now, be smart, think before you speak, think before you act, make smart choices. And after sitting through today, you now know the story and the facts of a man who made a dangerous choice. The choice to get behind the wheel, the choice to drink, choice to drive, choice that we now know led to a commission of crime. The defendant is not just someone who appeared on that road that night. He's not just put in that position. It takes choice after choice after choice to be there, to be on that dash cam that we all watched. And now has come the time for those choices to meet their consequences. You see, in this case, the defendant chose on July 25th, 2025, in Harris County, to operate a motor vehicle in a public place while intoxicated. And this goes back to the very beginning. When I was talking with you up here in the jury selection phase, these are the same checklists. Nothing's changed, except that now every single one of them has a piece of evidence behind it for you to check it on. Every single point on this list has been hit. And I want to come back to intoxication in a moment, because like I said, the defense is going to get a chance to come up here and speak to you. But before they come up here, I anticipate they're going to ask you to not look at what you've seen, but look at what you haven't seen. Try and focus on what you haven't seen in the evidence. They might say it was a long night. His red eyes because he was tired. It was 2 a.m. Might be an odor of alcohol because someone spilled something on him. Any of that in evidence? Is there anything that supports that? You see, when I talk about my dog star in jury selection, circumstantial evidence, connecting the dots, there is nothing in the charge that the judge just read you that says you are to leave your common sense at the offered TSA checkpoint downstairs. They have to come to the first floor. It's that you have to use it right now to know the defendant hit every single one of these elements. So I'm going to get another chance to speak with you after they have their opportunity. And I appreciate your attention this far. When I come back, I'm going to ask you to continue to use that common sense and reach a just outcome. Thanks.
Okay. Thank you. Are you going to do it? Do you want to split it? You got it? Okay.
Good afternoon again. My heart is in my visa. And I don't know. Maybe so I'm gonna do a really good job for Alejandro. But before we get started, I want to take a minute to look at the jury instruction. So in the jury instruction, judge talked about the ability to disregard evidence if you feel like it was unlawfully obtained, which means you have the power to not consider something that you feel like wasn't obtained legally. I'm specifically referring to the stop. If you feel like the stop was not a good stop, you as a jury have the opportunity to disregard everything that happens after the officer stopped Alejandro. Now, Officer Escobar, he got on the stand and he said that, he was swerving all over the lanes and he was posing a threat to other people. But then when you look at the video, Alejandro may have been swerving slightly between his lane, right? But the law says that you are instructed that an operator on a roadway divided into 2 or more clearly marked lanes for traffic shall drive as nearly as practical entirely within a single lane. It doesn't say that you can't move back and forth in your own lane. Also talk about you may be able to move if it can be done safely. Officer Escobar said that, well, the court wants you to also show that they were posing a threat to other people. Nobody honked at Alejandro, nobody hit the brake, nobody tried to swerve to avoid him. And at every time that the officer says that he went out of his lane, there was at least a full lane between him and another vehicle. At no point in that video do you see Alejandro's truck straddle the line. At no point was he ever in 2 separate lanes. Now, Officer Escobar also told us that he likes to get behind Chevys and GMCs because they're commonly stolen. And then he mentioned that sometimes other motorists call in DWIs, but he likes to try to find his own PC. I'm not really sure what he meant by that because either you have probable cause to stop somebody or you don't. You don't go try to find it. He also said that he usually doesn't write tickets, and then he says that he sent cases to DWI to CYA or cover his ass. And I'm assuming that he don't usually write tickets because he takes people to jail to, I guess, CYA, right? To send them to the DWI unit, or because they're failing to maintain a single lane, but they're not posing a threat to anybody. Now we'll talk about Officer Ward. Officer Ward, very knowledgeable about standard field sobriety tests, but that knowledge does nothing for you because he didn't administer them here. So you know you can get to apply it here, right? Now, what I think this is a power struggle because you have both Officer Escobar and then you have Officer Rohrer, who both kept saying that Alejandro was belligerent. He was uncooperative. He didn't want to answer questions. Well, if I asked you for an attorney and I asserted my fifth, why on earth would I answer your question? And as an officer, why would you describe him as uncooperative because he's asserting his Fifth Amendment right? You read his Miranda rights to him. You told him he had the right to remain silent, and then you get upset when he chooses to remain silent? That doesn't make any sense. The power struggle from Officer Escobar. You tell him, well, when you pull him over, he said, hey, what am I getting pulled over for? Why are you detaining me? Why are you asking me to get out of my car for failing to maintain a single lane? And then Officer Escobar says, Pennsylvania v. Mims, we don't play court in the street. Okay, so it's okay for you to play court in the street and gives me case law that he probably don't even know what that means, right? But the minute I question it and say, well, why are you doing this? It's a problem and I'm being belligerent or I'm being uncooperative. So it seems to me that the fact that he chose to assert his right and ask a question, why are you pulling me out? Why are you searching me? Do you have PC? You now want to take him to room 2 to be investigated for DWI for failing to maintain a single lane when he never actually departed from his lane or posed a threat to any other vehicle? That does not make sense. And if the piece does not fit, then like Attorney Sykes said, or her slide said, you must acquit. Now, they also talked about him losing, and I guess their case was based on him losing his mental or physical faculties. While he was driving, when the officer got behind him, he drove for a minute, but when he got ready to pull over, he turned on his signal light. He got into the left lane. He slightly yielded at a blinking yellow light. Then he turns into the parking lot without an issue. He stopped, he puts the car in brake, and when the officer opens the door, he has his seatbelt on. Seems like he was mentally capable to me. He says, officer, why are you pulling me out of the car? Why do I need to get out? What are you stopping me for? Seems mentally capable for me. The officer was actually pulling on his arm to get him out of the vehicle. He didn't stumble out. He didn't fall out. He got out of the vehicle. He stood there. When the officer cuffed him and walked him to the car, he was able to physically do all those things on his own, right? And then he got in the car, and I can admit, he started acting like an asshole, right? He was talking noise to the officer the entire time. But again, you pulled me over. I don't know why you pulled me over. You pulled me out of my car. I don't know why you pulled me out of my car. Now you're searching my car. You didn't find anything. And now you're taking me to room 2 to do an investigation. And mind you, at this point, he has not even mentioned a DWI. So Alejandro don't even know why he's being transported other than for failing to maintain a single lane. And that does not make sense. So of course, he's upset. And then when he gets to the station, and Officer Ward starts doing his questioning and saying, well, he didn't stand on the line. I don't know about y'all, and you have the opportunity to ask to see the video, but at every point on the video, he stayed on the black line. Now, maybe he didn't keep his feet together and his arms by his side, but officer already told you, I'm not doing these tests, I want a lawyer. So when you go to the back and you look at all the evidence that has been presented to you, I want you to think about everything from beginning to end. Was he really failing to maintain a single lane? If he was not, and you find that the officer just pulled him over because he liked to send stuff to DWI to CYA, or because Chevys are normally stolen, or because he wanted to find PC, you stop right there and it's a not guilty. If you decide, okay, well, yeah, he kind of was maybe moving out of his lane a little bit, and you get to the point where you say, okay, well, maybe they can go do a DWI investigation, you got to look at the investigation, and you also got to consider everything that was brought before you. Now, Officer Ward got on his stand, and he said about 3 or 4 times, I smelled a strong odor. Oh, it was a very strong odor. A strong odor. And then when I bring him his report, he reads it, and he reads just low enough that you don't hear him. And then I say, wait, read that part again. He completely disregards what type of odor it was and said, I smelled an odor of alcohol. So then I have to ask him a 3rd time, officer, read exactly what your report says. I smelled a slight odor. Is slight and strong the same thing? I mean, he wants y'all to convict based on that? I don't think I need to say anything else because I know y'all gonna come back with the not guilty.
Thank you. Okay,
Yes, Judge.
please.
So I'd like to pick up almost right where she left off there. The jury instruction for you is to look at Officer Escobar's side. It's absolutely right. You're to follow the law. And you see, like she just said, and I wrote it down because I liked it. You see him moving out of his lane a little bit. Then you go to the TWI investigation. That's exactly right. Moving out of his lane a little bit is what happened. And when he's looking for his own PC, it's not what happened here about calling in and finding PC based on a call. And for that, him referring to that, meaning he finds his own PC to do an investigation before pulling someone over, not pulling over just based on the call. He's checking it himself. So that's a little misinterpreted there. But in this case, it doesn't even matter because he sees the whole thing. He sees him moving out of his lane a little bit. And that's enough for failing to maintain a single lane at 2 a.m. in a lifted, tinted Chevy pickup truck here in Harris County. Now, let's go back to what I have to prove here. Remember this video from Port Iyer? I don't mind playing it. Where the ball comes out and we thought, what might run behind it? Oh, a kid? Well, I want you to look at the video from this footage. Where it looks like, as he goes through this light, that white line under his right tire, he's out of his lane a little bit, staying there, coming back over to the yellow line, out of his lane. And when the lights come on, how long does he take to pull over? I don't know about you or me, but if someone pulls over immediately, that seems typical. If someone drives for almost a mile and doesn't get in a right lane to pull over, but instead puts a blinker on, goes through a yellow, then red light to turn left and pass up more parking lots. Officer Escobar said that there's concern for looting on a lifted truck with dark tinted windows, and that in other investigations, he's allowed to, and has done in the past, pull someone out of the car for officer safety concern. But the fact of the matter is, he moved out of his lane a little bit. And by their own standard, we're on to the DWI investigation now. So now we're looking at the facts of what we saw on scene with the car, with him behind the wheel, and we're looking at what we see at the station. Back in board iron, in jury selection, we talked about these definitions and the faculties, right? How the law allows us, the state, to prove our burden of intoxication by the loss of normal use of mental or physical faculties due to the introduction of drug alcohol, right? That long sentence. What do we have here? Well, we heard from two people today, Officer Escobar, that he observed the defendant swerving, and we just watched that. That he observed the defendant pass several safe points to pull over, which gave him a concern for what the defendant might be doing in the car. He had red, watery eyes when he met him. There was an odor of alcohol. And then we heard from Officer Rourke, the DRE, drug recognition expert, that he observed the defendant swaying while he's standing at the station. It's not like there's cars passing by him. It's concerning. It's not like anyone's in the middle of traffic making him step aside or something like that. He's in a room. It's a quiet room, and he can't stay still. That, as Officer Rohr explained, is a sign of intoxication. We also saw red, watery eyes, an odor of alcoholic beverage, can't follow instructions, can't stand still, can't stand on the line, can't hold his hands by his sides, and we now know that that's important for SFSTs. That's important for determining intoxication because they're attention diversion. It's to see if you can listen to instructions and pay attention just like you have to behind the wheel. That's why if they find that SFSTs are okay, they let you on your way. The fact of the matter is the defendant never gave the chance to conduct a full test of SFSTs, did he? Instead, he sat there repeating questions that were asked just minutes before, and he declined to do the test, and he declined to run the test. So what do we know about the defendant? We know that he has the red, watery eyes and slurred speech, he's swaying. And for these signs of intoxication in general, right, in general, what we know from Officer Escobar and Officer Rohr, that these are the signs that indicate to them that someone has lost the normal use of their faculties for the operation of a motor vehicle. Whether or not they're belligerently drunk is not what the standard is. These signs indicate to officers every day that they have lost their faculties to drive. And what do we see in the defendant? At the station, the same signs, red, watery eyes, slurred speech, swaying, can't follow instructions, smell of alcohol. So what we see from Officer Rohr, again, the drug recognition expert with over 350 DWI cases and nearly thousands of SFSTs administered, he reached one final conclusion, that there was no doubt in his mind, based on his years of experience and training, that the defendant fit this box. And if sometimes you don't want to take the officer's word for it, sometimes the defendant can tell you themselves.
Against me tonight. Yeah, put me in. Take me in. Fucking do. Fucking do.
Give me a PI. We learned what that meant. Give me a public intoxication. I don't care. Quote him, I don't give a fuck. Give me a PI. Give me a public intoxication charge. If you don't want to take it from the officers at the station minutes or hours later, take it from the defendant minutes after he's pulled from behind the wheel, that he's intoxicated. And so we go back to our checklist. And at this point, we know that every single element is hit. We know that on or about July in Harris County, defendant Alejandro Gonzalez did operate a motor vehicle in a post-mix while intoxicated. And again, I won't play it again, but the defendant's own words give you more than enough to show you that at the time of him driving, he was intoxicated. And that's why at this point, we've come to what's known as the proverbial passing of the baton, right? This is the end of the relay race, the last lap. And it's my job to make sure that you are well equipped for your job, to go back there and ask each other questions and reach a just outcome. And at this point, we feel as a state that we have done that beyond a reasonable doubt. So when you go back to that jury room and you deliberate, I want you to remember two things. All the evidence that you saw from the witnesses reached one conclusion. He was intoxicating with time. And second, to put the defendant himself saying, give me a public intoxication, because he's not even hiding himself. Take me in. I don't give. Give me a PI. Charge me with intoxication. He knew in the moment that his consequences were coming. That his actions, his choices, had finally met their mate. And at this point, the only option is to find the defendant guilty of driving while intoxicated. Thank you.
All right, thank you. Okay, I think it's time for you guys. Are you ready? Should we bring this up?
Yes.
Yes.
Yes. Yeah.
Yeah, Archie, do you mind handing this to them? And then, if you mind taking them back to the jury room so they can deliberate.
All right for the jury.
Remember, officer, off the record. Remember, is Mitchell going here?
This is the 26th one.
Yeah, it's. Thank you. Okay. Good luck. All right, we're in recess. Yeah, she can't go over it with Hey, or you know if they're gonna get working on, because I bet they're gonna want the driving video. My feeling is that they're gonna want the drive. I mean, well, it depends when that's right. Ready? Ready? Okay.
Yes.
Yeah.
Yeah.
Judge, we're gonna grab our chief really quickly. She's just in the different.
Yeah.
Think so?
It's a breach. Thing.
Let me get, I mean, if you want to start gathering them.
Yes.
We're good, Judge.
Okay, you bring.
He's ready?
Yeah, we're ready. All right. Ladies and gentlemen of the jury, you have reached a verdict. Is it unanimous?
Yes.
Okay, if you would mind handing the paper over to Deputy Newell.
And there it is. After hours of testimony, arguments, and legal back and forth, the jury has spoken. Guilty. But here's the real twist. This case was never just about whether he was intoxicated. It all hinged on one critical question. Was the traffic stop even legal in the first place? If the jury had doubted that for even a second, all evidence could have been thrown out. So let me ask you, Did the defense do enough to challenge that stop? Or did the prosecution's common sense argument win this case? Drop your verdict in the comments below.
Hand me the verdict, all right, guys? Okay, in cause number 257-5231, the state of Texas versus Alejandro Gonzalez, we, the jury, find the defendant guilty of driving while intoxicated. Would you like the jury polled? No? Okay, you may be seated. Okay, ladies and gentlemen of the jury, this will take us to the next phase of the trial. We'll now begin the punishment phase of the trial. There are several things that I have to talk with the lawyers real quick, so I'm going to excuse you for literally about 1 to 2 minutes, and then I'm going to bring you right back in, and then we'll continue. Okay? Okay, please, if you don't mind.
All rise for the jury.
Let's go on for a second. Lawyers, do you mind coming up real quick?
Yes.
You still want to go? Okay, what?
It's a 15-month probation with standard conditions of TRAS, DWI education, repeat offender course. It would be 30 hours of community service. And then
It's a second offense, though. I think that on a second, though, there's a 30-day minimum jail sentence, though. That's the problem. When the jury finds the defendant guilty, my reading of the statute, if that's the case, if you agree, okay. But I think that there is still a 30-day minimum. My reading is 30. I mean, because I was just now looking at it.
Is it 35 or probation on effective?
30, this reading of the statute, because I was looking at it here. Except as provided by subsection B, an offense under the section 49.04 or a class A misdemeanor with a minimum fine with a minimum term of confinement of 30 days if it is shown at trial of the offense that the person has previously been convicted one time of an offense relating to the operation of motor vehicle while intoxicated, or aircraft or watercraft.
So it's 30 at trial, but 5 before trial is what this statute is.
I even reached out to my staff lawyer just to be on the safe side. And what they said is it's a minimum term of confinement of 30 days if it's found at trial that he's found guilty on the second.
But just technically, he hasn't been guilty. He hasn't been found guilty of the second. It's just he's been found guilty of the DWI.
Yeah, I mean, and we need to do that as well. So it's either it needs to be stipulated, or we have to have put on evidence that there's a second, and that would be, a fingerprint examiner, if there's no stipulation to it.
Would you all be amenable to doing it as a person?
I mean, if you want to abandon the enhancement,
Which is what I'm saying.
and then we'll go the minimum of 5.
Right, this is what I'm saying. Would y'all be agreeable to doing it on first, but he's still doing the 5 days, and with the probation 15, he does 5 days as a condition, but we do it on the first.
Yeah, you have my blessing.
If that's
what you want to
we
do.
can do it that way. I mean, 'cause at the end of the day,
We'll just put it on the record that all the parties agreed to it, and then, yeah. Okay, okay.
Judge. There's an agreement,
Yeah.
and then
Right, we'll have it stipulated on the record that everybody's in agreement.
We'll do it. Yeah, we'll contact the client first.
Yeah.
And
But
then-
we'll stipulate it on the record for you.
Okay, no problem.
Yeah.
And then let me,
Yes.
I mean, I'm gonna go excuse the jury then, I guess.
Would we have the opportunity to talk to them?
Yeah, of course. Yeah, but let's do everything here first. Let's get it done. Once it's done, at that point, talk to them for 5 minutes and then you guys can have it.
Yeah, because if we go for plugs now.
All right, I'm gonna go ahead and
That's gonna run.